Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. Today, we're going to be talking about Medicaid planning for individual clients without a spouse and situations where an individual has already made previous gifts that will be considered in the look-back period. If you have any questions during today's webinar, feel free to type them into the questions tab of the GoToWebinar dashboard. And also, if you're interested in a copy of the handouts or the slides from today's webinar, you can download those from the handouts portion of the GoToWebinar dashboard as well. Again, my name is Amber Hines, and I have been working with elder law and estate planning attorneys for the last 15 years. Mostly on Medicaid crisis planning and Medicaid compliant annuities. I am insurance licensed in all states, and I hold my Series 65 license with FINRA as well. And I created Ashbur, which is an insurance agency to assist other advisors as well as attorneys with pre-planning solutions for long-term care, such as hybrid long-term care insurance policies, as well as crisis Medicaid planning. How my company can help you and your clients: we offer complimentary case analysis, so we will help you to determine the optimal amount to go into a Medicaid compliant annuity, the optimal term of the annuity, and which assets your clients may consider annuitizing, especially if you're in a state that considers IRAs or retirement accounts to be countable assets. We can look at doing direct transfers of those types of accounts into a Medicaid compliant annuity so that the client is not incurring all of the tax consequences at one time. Also, if you have clients that have existing non-qualified annuities that are going to be considered a countable asset, we can look at doing a 1035 exchange of existing annuities or life insurance policies into a Medicaid compliant annuity as well. So if we receive information on your clients as far as the type of assets that they own, their age and their income, cost of care, things of that nature, we can help you to put together a plan that would make sense for the clients and take into consideration the different type of assets that your clients own. We offer assistance from the beginning to the end of a case. So we're able to provide quotes for the annuity, assistance with the actual funding of the Medicaid compliant annuity. And then if you have a situation where a client purchases an annuity through our office and that client passes away, we will reach out to the state Medicaid agency if they're listed as a beneficiary and determine whether the state has a claim against the annuity. And if not, then we'll assist the secondary beneficiaries to receive anything that's remaining in the annuity contract. We work with A-rated insurance carriers, and oftentimes our fees are lower than our competitors when we're dealing with annuities that do have a processing fee involved. We offer top-notch customer service. We get back to our clients the same day in most cases, or the following day within 24 hours with a proposal or a recommendation of how we can assist them to actually purchase a Medicaid annuity if that is something that makes sense for them. It's not all cases are meant for a Medicaid compliant annuity, and we will let you know that if that is the case as well. So today we're going to be talking mostly about individual clients that do not have a spouse. And so when we are dealing with an individual client that is trying to qualify for Medicaid from an asset standpoint, in most states, we can have around $2,000 of countable assets in order for that client to receive Medicaid. So this is obviously a very limited amount of assets that an individual is able to keep and still qualify for Medicaid. This is going to include money that is in clients' checking, savings, investment accounts, any type of liquid assets. We need to spend an individual down to $2,000 or less This number does vary slightly by state. Missouri is a state that lets clients keep a little bit more, around $5,000 for an individual, but the majority of states we need to spend an individual client down to $2,000 or less in assets. When we're dealing with the income limitation for an individual, the Medicaid applicant's total income must be less than the cost of care. And the only exception to this is states that have an income cap or are considered to be income cap states. If you are in an income cap state, the current cap amount in the majority of states is right around $2,500. If the individual's income is more than $2,500, then we would need to establish a qualified income trust or a Miller trust in order for the excess income to flow through the qualified income trust and meet the income limitation if you do practice in an income cap state. Some other resources that are considered protected or non-countable for Medicaid qualification purposes are the individual's home, automobile, household goods and personal property, an irrevocable funeral trust or a burial policy. And then also some states do consider the individual's IRAs or retirement accounts to be a non-countable asset as well. If your Medicaid clients do have excess assets that we're looking to plan for, we usually are looking at developing a Medicaid eligibility plan, and this can include increasing or improving non-countable assets, so spending money on making home improvements, purchasing a new car, anything that would be considered a non-countable asset, we can spend money down by purchasing non-countable assets. Also, we can purchase prepaid burial policies or funeral policies for a client if there's a small amount of money that needs to be spent down. And then if an individual does have credit card debt, a mortgage, or other debt that needs to be paid off, this is usually one of the go-to items that we would be looking to spend the assets on so that the credit card debt and other debt is not having to be paid by children or somebody else that would be responsible for that debt. If there is excess assets left after all of these items are considered, then we would consider purchasing a Medicaid compliant annuity that complies with the Deficit Reduction Act of 2005. A Medicaid compliant annuity is a single premium immediate annuity. It's never a tax deferred annuity. A tax deferred annuity is always going to be considered an asset for Medicaid qualification purposes, with the exception of Texas is kind of a unique state with deferred annuities and IRAs, but in the majority of situations, a deferred annuity is going to be considered an asset because there is a surrender value or a lump sum of money that the client is able to access from the insurance company with a tax deferred annuity. A single premium immediate annuity is strictly an income stream because we're using a lump sum of money to convert an asset into an income stream. And once an immediate annuity is annuitized, then it is only income. There's no longer any cash surrender value that can be accessed from that contract. As a result of the Deficit Reduction Act of 2005, immediate annuities that are used in Medicaid planning must meet strict requirements, which I'm going to go over next. And there's very few insurance companies out there that offer Medicaid compliant annuities. There's hundreds of insurance companies that offer immediate annuities that will convert a lump sum of money into an income stream, but there's less than 10 insurance companies currently that offer a Medicaid compliant contract. So it's really important if your client is working with their own financial advisor that they are looking at purchasing an annuity from an insurance company that actually offers a Medicaid compliant contract. The language that is required in a properly structured immediate annuity in order for it to comply with the Deficit Reduction Act. All of the items are listed on the screen here. The 5 requirements of a Medicaid compliant annuity are that the annuity must be irrevocable, non-assignable, make equal payments, be actuarially sound, and list the state as a beneficiary. And all of these requirements, the irrevocable requirement means that the annuity must be completely irrevocable in that we cannot change any aspect of the contract. We can't change the payment amount, the payee, the owner of the annuity, the date of the payment that comes each month. So we would not be able to change any aspect of the annuity contract if it is completely irrevocable. Also, the annuity must be non-assignable, meaning that we cannot assign the annuity to a company like J.G. Wentworth or Peachtree for a lump sum of money. So if we send a Medicaid compliant annuity to a company like J.G. Wentworth or Peachtree, they will come back to us and tell us that they can't purchase it because it is non-assignable and doesn't have any value on the secondary annuity market. Also, the annuity must make equal payments. So we can't have any type of balloon or increasing payment on the annuity. Prior to the Deficit Reduction Act, we were able to do balloon style annuities, which was basically a way to backload the annuity contract and make a very large payment at the end. But now the requirement is that the annuity must make equal payments through the life of the annuity contract. Also, the actuarially sound requirement means that the annuity must be structured with a time frame that is going to pay out within the client's Medicaid life expectancy. It can be structured for a shorter period of time. We just cannot do a longer time frame than what the client's remaining Medicaid life expectancy is. And finally, the state Medicaid agency must be listed as a remainder beneficiary to the extent that they would provide Medicaid benefits to the Medicaid applicant. There are some exceptions to this rule. If there is a minor or disabled child, they can be listed as a primary beneficiary before the state. But in most cases, the state Medicaid agency must be listed as the primary beneficiary only to the extent that they actually provide Medicaid benefits for a client. So first, we're going to look at a case study that does not have any previous gifting. We're dealing with a single person named Mary, and Mary is 80 years of age. After living at home with dementia for years, she is now in need of nursing home care. Mary's family feels that she could live for another 5 years in this sort of supportive care environment. So they're looking at different planning options for this client in order to save as much money as possible and not just spend down all of her assets. Her total accountable assets are $200,000. This is all after-tax dollars, so cash that is in a checking or savings account. We're not dealing with any retirement assets in this case. And then Mary has monthly income of $1,000 per month from Social Security and pension, and her private pay at the nursing home is $10,000 per month. If we first calculate Mary's monthly income shortfall, the nursing home is charging her around $10,000 per month, and she only has monthly income of $1,000 per month. So her shortfall on a monthly basis is $9,000 per month that she would be depleting from her current assets, from checking or from savings money that she currently has as far as her assets go. If Mary does no planning at all, she's going to exhaust her entire life savings of $200,000 in just under 2 years. And that was determined by just taking the $200,000 that Mary has left and dividing that by the $9,000 per month that she is short from being able to pay her nursing home costs, and her assets will be depleted within 22 months. Because Mary's family anticipates her living for many more years, doing nothing at all is not a great option. So we're going to look at doing a gifting plan for Mary, which would allow for her to make an immediate wealth transfer or gift to her intended beneficiaries. And then it also allows her to qualify for Medicaid at the end of an ineligibility period or a penalty period that is associated to making this gift within the 5-year look-back period. As a result of the Deficit Reduction Act of 2005, in order to start a penalty period for Medicaid qualification purposes, the applicant must be income and asset eligible. So I like to think of the $200,000 that Mary has as going into 3 different buckets. We can hold back around $2,000 of the $200,000 as Mary's resource allowance. I usually keep that back to like $1,500 or $1,800 that she is going to keep in her checking account as countable assets. And then anything that is remaining of the $200,000, that amount is going to go into the remaining 2 buckets of either making a gift or using the remaining amount to purchase a Medicaid compliant annuity to pay through that penalty period. So first, we're going to determine the monthly income shortfall, which we've already determined to be $9,000, and that was by taking the $10,000 cost of care, subtracting out monthly income of $1,000, and we know that Mary is short each month $9,000 from being able to pay her nursing home costs. Next, we're going to determine the burn rate, or the amount of money that can be used to gift, as well as the amount that can be used to purchase an annuity. The income shortfall of $9,000 is added to the divestment penalty divisor in this state of $11,231, and our total burn rate in this case is $20,231. Many people ask the question of what is the divestment penalty divisor and where can you find it? So Medicaid calculates the penalty period or the ineligibility period for gifting assets within the last 5 years by dividing the total gift by the divisor. And this divisor amount is supposed to be the average cost of 1 month in a nursing home in your state. So if we look at the different divisors across the country, states like where I'm at in Georgia, the divisor is going to be a lot lower than a state like New Jersey or Pennsylvania that is up north, where the cost of care is a lot higher than where we are in the South. And so you can find the divisor in either your state Medicaid manual or on our website at ashbur.com. We have those listed for each state as far as what the average cost of 1 month in a nursing home should be according to your state. Once we determine the burn rate, we're going to divide the burn rate by the spend down amount of $200,000 that Mary has left. And we determined that the term of this plan is going to be 9.88 months. I rounded that from 9.88 up to a 10-month time frame. And next, we're going to determine the amount that can be gifted to Mary's intended beneficiaries. So we're going to multiply the term of 10 months by the divisor of $11,231. And we determined that Mary is able to make an immediate gift to her intended beneficiaries of $112,317. We're calculating the penalty period in this case by basically taking the total gift of $112,000 dividing that by the average cost of 1 month in a nursing home, or the divisor amount that we just talked about. And that is how the penalty period or the private pay period is determined when we're looking at how long a client is going to have to privately pay. So we add up all of the gifts in the last 5 years, divide by the divisor, and that tells us how long the client will have to privately pay for their own care before Medicaid starts picking up the bill. Next, after we determine the gift amount of $112,000, we subtract that gift from the spend down amount of $200,000, and we figure out that we can purchase a Medicaid compliant annuity for $87,683. We're going to structure the annuity over a 10-month time frame because this is going to match the time frame of the private pay period or the penalty period that is going to be assessed based on the gifts that are being made of $112,000. If we put $87,683 into an annuity structured over 10 months, the annuity is going to make monthly payment back to Mary of $8,770, and the total payout is going to be slightly more than the single premium amount at $87,700. It's important to note that an annuity can only be structured for a whole number of months. So we could structure the annuity for 9 months or 10 months, but it could not be for a time frame of 9.88 months. It must be whole number of months when we're looking at structuring the annuity contract with an insurance company. In this case, we chose a 10-month term to match the penalty period that Mary would need to privately pay through. During the penalty period, we're going to add up Mary's Social Security and pension income of $1,000 per month plus the annuity payment at $87.70 and determine that Mary's total income during the private pay period is going to be $9,770 per month. With Mary having a cost of care of $10,000 per month and total income of $97.70, her shortfall on a monthly basis is $230 each month. Many people ask the question of, why can't we create exactly $10,000 per month of income in order to exactly meet what Mary's cost of care is? And it goes back to the idea that in order for a penalty period to start, a client must be income and asset eligible for Medicaid. And so if we create exactly the amount of income that's needed to pay the nursing home, the client is not going to have an income need. So we intentionally build in a small monthly income shortfall so that the client would be considered income eligible, and so that the 10-month penalty period would start that is associated to making the $112,000 gift. If we create exactly the amount of income, then if we exceed the amount of costs of care, if the income exceeds the cost of care, then the penalty period would not start. If we are in an income cap state or a state that requires a Miller Trust or a qualified income trust, then the income from the annuity is going to go into the qualified income trust during the private pay period and would be used on a monthly basis to pay the nursing home cost as the annuity makes payments. So there's just an extra step there if we're dealing with a income cap state where the annuity payments are going to go directly into that trust and then use the annuity payment still to pay the nursing home bill. The economic results of doing the gift and annuity strategy for Mary is that she was ineligible for Medicaid for a 10-month time frame, which is the private pay or the penalty period. During that 10-month time frame, Mary has monthly income of $9,770 per month. And so she has a monthly income shortfall during that 10-month time frame of $230. She would become eligible for Medicaid in month 11. If you're wondering how the $230 per month is paid, that can either be covered by the resource allowance that Mary keeps of $1,800 or $2,000 in her name. Otherwise, if it's a larger shortfall that is created by on a monthly basis, then that may need to be covered by the giftees. But in a lot of cases, the resource allowance that the client retains is a sufficient amount to cover the monthly income shortfall. The advantages of the gift and annuity strategy is that Mary was able to gift around $112,000 to her children or to her intended beneficiaries, which is more than 50% of the $200,000 that Mary has left in assets. And the gift in this case was made with all after-tax dollars. It wasn't any retirement assets that we were gifting. So we're not concerned about any income tax consequences of making this $112,000 gift. Also, Mary is going to receive Medicaid in month 11 after this private pay period is over with. The disadvantages or potential disadvantages in this case is if Mary does not live through the 10-month private pay period, she would not have gained any economic benefit from Medicaid because Medicaid is not going to start paying the bill until month 11 after the private pay period is over with. So in all of these cases, life expectancy is a factor. It's not going to make sense to do a gift and annuity strategy for a very long period of time. In some cases, depending on how many assets are remaining, the penalty period can be 2 or 3 years. And so if we're dealing with a longer penalty period and we have a client that has a very limited life expectancy, it may be better to just continue to privately pay or do a standalone Medicaid compliant annuity without a gift in order to get the individual immediately onto Medicaid without having to privately pay. So we're always going to consider the life expectancy of the Medicaid applicant as to whether a gift and annuity strategy makes sense for them. If we assume that Mary passes away 6 months after the annuity is purchased, you'll recall that the state Medicaid agency must be listed as a primary beneficiary to the extent that Medicaid benefits were provided. But in this case, since the annuity was being used to pay during a penalty period, Medicaid was not actually covering the bill during that 6-month time frame that Mary was alive. So assuming the state did not provide any Medicaid benefits and we received a clearance letter from the state, then the secondary beneficiaries or the children in most cases are going to be listed as a contingent or secondary beneficiary, and they would receive the remaining amount that is in the annuity contract. If we assume that Mary passes away 12 months after the annuity is purchased, nothing is going to happen to the Medicaid compliant annuity. There's not going to be any impact on it because the annuity was structured for 10 months and it would be done paying after 10 months. And if Mary passes away in month 12, then the annuity is already done paying out and there isn't anything to be settled with the insurance company because it was already paid out in month 10, even though she passed away in month 12. The time frame to implement a gift and annuity strategy, usually a gift is made, the annuity is purchased, and the client applies for Medicaid all in the same month. By doing all of those 3 things in the same month, we're able to establish that Mary is otherwise eligible for Medicaid or asset and income eligible for Medicaid, and we have submitted a Medicaid application to start that private pay or penalty period. When we disclose to Medicaid that a gift or a transfer has been made within the last 5 years, then Medicaid is going to determine the penalty period by taking the total gifts, dividing that number by the divisor, and that is how they determine the penalty period or the private pay period. We're going to use the Medicaid compliant annuity payments to pay during the penalty period. So in our example, the penalty period we calculated was 10 months, and then we structured the annuity for a 10-month period as well to match that private pay period. After the private pay period is over with and the annuity is done paying out, then the client is going to become Medicaid eligible. And so we line up the penalty period with the annuity payment so that there isn't any overlap of the annuity paying for too long and the client having excess income. So after the penalty period is over with, Medicaid is going to start covering the nursing home cost. Now we're going to consider a fact change where a client has made previous gifts before they have come into your office, and how we can deal with the previous gifts that have been made within the 5-year look back period for Medicaid. So if we assume that while your office is reviewing the client's financial statements, you discover that Mary has made previous gifts of $20,000 over the last 5 years or during the 5-year look back period, we're going to look at how this will change the results of the plan if there have already been gifts that have been made within that 5-year period. If gifts were made during the 5-year look back period, we usually need to be adding those gifts to the spend down amount because the previous gifts will extend the private pay or the penalty period. Initially, we had a spend down amount of $200,000, but now that we have previous gifts of $20,000, we're going to add that $20,000 to the $200,000 and determine that our new spend down amount or assets that are available to be gifted and used to purchase an annuity are $220,000. If we again divide that by the burn rate that we already determined of $20,231, now the term of our plan is 10.87 months, or in this case, we round it up to an 11-month time frame. We're going to do the exact same thing that we initially did to determine the gift amount initially. We're going to multiply the term of the plan of 11 months by the divisor in this state of $11,231, and the total gift amount now is increasing from $112,000 up to $123,548. The immediate gift of $123,548 does already include the previous gifts because those are going to be penalized gifts within the 5-year look back period. So the net gift amount or the immediate gift amount that the children or the intended beneficiaries are going to receive right now is $103,548, and that's just subtracting out the previous gifts of $20,000 that have already been made. So this is the actual amount that is going to be gifted now, even though the penalty period is going to be based on the total gift of $123,548. Next, we're going to determine the monthly annuity payments and how much can be used to purchase the Medicaid compliant annuity. We're going to subtract out our new gift amount of $123,000 from our spend down amount of $220,000, and the annuity single premium, or the amount going into the annuity now, is going to be $96,451. We're going to structure this larger amount over an 11-month time frame to match the 11-month penalty period, and we determine that the monthly payment on this annuity is going to be $8,770 over an 11-month time frame, so that the total payout is $96,470. During the penalty period, Mary is going to have total monthly income of her Social Security and pension at $1,000 plus the annuity payment at $87.70, so that her total income during this 11-month time frame is $9,770 per month. The shortfall again is going to be $230, and that is determined by taking the cost of care at $10,000 and subtracting out Social Security, pension, and the annuity income at $97.70. So she is short on a monthly basis of $230 each month. The economic results is that Mary is ineligible for Medicaid for an 11-month time frame. This again is the private pay or the penalty period. She has total income of $97.70. Her shortfall on a monthly basis is $230. That can be covered by either her resource allowance or by the giftees. And then in month 12, Mary is going to be Medicaid eligible after that 11-month time frame is over with. The advantages of this plan is that Mary's children are receiving a total gift of $123,548. This does include the $20,000 of gifts that were already made within the 5-year look-back period, but this is still an amount that is over 50% of the remaining assets of $220,000, or the $220,000 that we have as a spend down amount. And Mary is going to start receiving Medicaid in month 12. We have the same potential disadvantages here. If Mary does not live through the 11-month penalty period or the private pay period, then Medicaid is not going to start paying until month 12, so there's not any economic benefit that is gained if she does not live through that penalty period. So we want to consider the life expectancy of Mary when we're implementing this type of planning. The financial impact of the $20,000 in previous gifts is, first, the penalty period was increased from a 10-month time frame to an 11-month time frame. So we needed more money to purchase the Medicaid compliant annuity to cover that extra month of penalty. The gift amount increased from $112,000 up to $123,000. That is also going to, the increased penalty period is also going to increase the amount that is needed to purchase the annuity. The annuity increased from $87,683 up to $96,451. And then the annuity term is going to increase from 10 months up to 11 months, and that is basically to mirror what the penalty period is, or to match what the penalty period is, so that Mary has sufficient income to last during the penalty period that Medicaid is going to assess. In this case, the math worked out that Mary had sufficient assets of $200,000 to purchase a Medicaid compliant annuity in order to privately pay during the 11-month penalty period in order to cover that penalty period. But in some cases, there are situations where clients have made large previous gifts, let's just say $100,000 if they gifted a home, or if they made several gifts over the last 5 years before they came into your office that exceed the amount of assets that are remaining. Let's just say they only have $10,000 of assets remaining, but they've made previous gifts of $100,000. We will have to do additional planning in a case like that because we need to get Medicaid to assess a penalty period of, we'll just say a penalty period is going to be around 10 months by dividing the gifts of $100,000 by a $10,000 divisor amount. The client's going to be ineligible for 10 months, but they only have $10,000 of assets remaining in order to pay during that 10-month penalty. So there's additional planning that would need to take place in order to make a situation like that work. And so if we do have a situation where there has been large previous gifts and the client does not have sufficient assets to cover the penalty period or to pay during that penalty period, some of the solutions that we look at to help with previous gifts is to ask the family to help to pay during the penalty period. If they have that money available, then we can have a family member step in. A lot of times the children will help pay during a penalty period if that becomes necessary. Also, if a gift that was previously made, if that can be returned to the Medicaid applicant, then that will help us to cure the gift and to basically make the numbers work out where we're still able to purchase an annuity to pay during a penalty period and likely be able to make a gift where the family is still going to benefit. So those are two options. And then a final option would be if your state allows for a promissory note to be used in order to cure gifts that have already been made, then that is also an option. There are a lot of states that don't allow for a promissory note to be used to cure a gift, but if your state does allow for that, then that would also be an option, and you would need to just make sure that the promissory note has the Medicaid qualifying language in it in order for that to work to decrease the penalty period or to cure a gift. Some of the factors that we consider when determining which option to choose, whether the money should be returned to the Medicaid applicant or whether the family can step in and pay, or if a promissory note should be used, we have to obviously look at the amount of the previous gifts. If we're dealing with previous gifts of $200,000 that have been made within the last 5 years, that is going to incur a 17.8 month penalty period. Whereas if we're dealing with a $20,000 gift that has been made within the last 5 years, that is going to incur a 1.78 month penalty. And this is based on the divisor that I was using throughout of around $11,231 per month. So if you're in a state where the divisor is only, say, 5,000, then these penalty periods are going to be even longer. We also have to consider whether the gifts are curable or if they can be returned to the Medicaid applicant in order to cure the penalty period that would result from the gifts that have already been made. We need to consider whether your state recognizes each strategy as a planning tool. So if you're in a state that does not allow for promissory notes, then we obviously can't use a note to cure a previous gift that has been made. Also, we want to consider the health of the Medicaid applicant. In other words, will he or she survive the penalty period? If we're going to implement this type of planning and we know that the penalty period is going to be pretty lengthy, but the Medicaid applicant is only anticipated to live for another handful of months, then it may not make sense to go through all the trouble of implementing this type of plan if they're not going to survive past that private pay period. And then finally, we need to consider the amount of resources that the Medicaid applicant owns in order for them to privately pay through a penalty period, or for them to purchase a Medicaid compliant annuity to pay during that private pay period. A lot of times it works out where there have been previous gifts, but the Medicaid applicant does have enough assets left in their name to purchase a Medicaid compliant annuity in order for the numbers to work out and to still allow them to pay during that private pay or penalty period. And now I will leave the last 15 minutes or so to answer any questions that people have related to the slides that we just went over, or just Medicaid planning in general for individuals. Not seeing any questions yet. I'll just wait a couple of minutes here. Okay, well, I'm not seeing any questions from anybody yet, but if you think of questions after today's webinar, you can feel free to reach out to us either by email using the email address that you're seeing on the screen, or by calling the phone number that is on your screen as well. And so somebody does have a question here. Do you have any trouble getting a short-term annuity or an annuity for an elderly person? The answer to that question is no. Depending on the state that you're in, that really determines which insurance companies we can use for the Medicaid compliant contract, but we do work with insurance companies that are able to issue annuities as short as a 2-month time frame in order to cover a penalty period like this. And they will issue annuities up to age 100, and they're a guaranteed issue regardless of the amount of assets or regardless of the health of the client. They will be a guaranteed issue as long as the client is under the age of 100 or younger, and they are looking to apply for Medicaid. So the answer to that question is no, we don't have any trouble getting short-term annuities or an annuity for an elderly person. Another question here is, what is the sweet spot for this type of plan in comparison to simply doing the Medicaid compliant annuity? That really comes down to the life expectancy of the client. If we're dealing with a lot of assets, say 500,000 or 700,000 in assets, and we know that the penalty period is going to be for 3 or 4 years, depending on the state that we're in, it may make sense to not do this type of planning because the penalty period is going to be for a very long period of time in comparison to the average time frame that somebody is going to survive or live in a nursing home is between 2 and 3 years. So it really comes down to how long the term of the plan is going to end up being and what the life expectancy of that client is. But I would say that the average time frame that we see for a gift and annuity strategy is usually around 10 or 12 months for implementing a gift and then also purchasing a 10 or a 12-month annuity. Those were great questions. I don't see any other questions at this time, but like I said, if you think of anything after today's program, feel free to reach out to me either by phone or email. Like I said earlier, we do offer complimentary case analysis. So if you have a situation that you're unsure as to whether an annuity would make sense, feel free to reach out and just ask whether it makes sense for the client, and we're happy to bounce different ideas off of the law firms or the advisors that we work with. Also, join us for next month's webinar because we're going to have attorney Jeff Belomo from Pennsylvania on our program in the beginning of November. He's going to be talking about how he has built his practice working with other healthcare professionals and with other financial advisors. So be sure to tune in for our November webinar as well. I want to thank everybody for joining me today, and I look forward to talking with all of you soon. Thank you.